Good afternoon, everyone, and thank you for attending today's travel law webinar. My name is David McClung. As president of Baxter Travel Media, it is my responsibility to you, our readers, to ensure we're delivering the industry news and information you need to run profitable businesses and maintain successful careers. Baxter Travel Media has been a leader in the anti-spam resolution since 2003 and is in favor of stricter regulations to protect everyone's best interests. The Canadian anti-spam legislation will result in business practice changes for all of us who rely on e-communications to maintain and grow our client base. Its significance and impact cannot be underappreciated. It is my sincere hope that you will gain a better understanding of the legislation today in today's webinar, and take this information back to your colleagues to develop CASL implementation strategies for your workplace. I also encourage you to take this opportunity to ask questions of our experts. In the coming months, make sure you subscribe to our news outlets, Canadian Travel Press, Travel Courier, Press Today, and TravelPress.com, as we help prepare the industry for the impacts of the CASL. And now I'd like to turn it over to the experts, Doug Crozer and Tim Law of Heifetz, Crozer & Law, whose monthly column appears in Canadian Travel Press.
Thank you, David. This is Doug Crozer. To the audience we have today, if you registered for today's webinar in response to an email that you received about it, that sort of email might become an illegal communication if it was sent on or after July 2nd of this year. Tim and I are here today to introduce you to some of the highlights of Canada's anti-spam legislation, also known as CASL, which is the reason why what is now a legal communication may shortly become illegal. In order to do so, we want to provide at the outset a bit of context as to where CASL came from and why it exists. It seems to have come out of nowhere these past few months in travel industry media and consumer media coverage, but in fact, CASL has a fairly lengthy history. The legislative process for this federal legislation started about a decade ago, and the law itself, the legislation, was passed in 2010. Now, it wasn't put into force then, but the skeleton of what we now refer to as CASL has been in place since 2010. The skeleton existed, but you need flesh on the bones, which usually come in the form of various regulations, and drafts of those regulations were prepared and then circulated in the summer of 2011 in order to elicit feedback. Based on the feedback, there were some changes to the regulations, generally reducing the strictness of them. And then finally, in December of this past year, the regulations were finalized, and it was announced that July 1 of 2014 would be day one of this brave new world. It exists, CASL does, because governments have recognized the need to regulate some of the less positive aspects of the new technology that all of us have embraced. That's not just governments here in Canada, but governments through much of the developed world. CASL is not a Canadian-only initiative. That said, most of the commentators that have a knowledge of other countries' anti-spam regimes have characterized CASL as being one of the more aggressive, probably the most aggressive, the most strict of the various initiatives that have been implemented elsewhere in the world. So why are governments taking these steps? And that's a good question to ask, and it's a good place to start, because it's only by understanding what the government is trying to accomplish that you can best understand what it's doing. Law school students everywhere are taught earlier in their studies that legislatures don't just pass laws for the fun of it. They do so in response to a perceived problem and in the hopes of reducing, if not eliminating, that problem. And so we're taught to recognize the problem in order to then be able to determine whether the solution solves the problem, and then you can also go on to a second level of analysis and decide if it's the best way to solve that problem. The principle with which CASL started is simply stated. It's three words: spam is bad. And then the corollary of that principle is anything that reduces spam is good. But, as everybody knows, the devil's in the details. And in getting from those very simple basic principles to the regime that we're looking at now, we've gone from 7 or 8 words to a multifaceted regime where you have to, in order to understand CASL, you have to look at the legislation itself, regulations that have been passed by the CRTC, regulations that have been passed by Industry Canada. There's 2 sets of CRTC guidelines on the interpretation of those regulations. There's an FAQ publication from the CRTC, and there's an expectation of at least 1 and perhaps 2 more FAQs coming from the CRTC. And there's a regulatory impact analysis statement, everybody calls it a RIAS, R-I-A-S, which in a non-binding way tries to give the government's interpretation of what they're trying to do in the things that are binding. And as I said, they all have to be understood if one is truly to understand CASL. Obviously, in the time we have today, we're not going to try to get into that specific detail. We're dealing with a high-level introduction to the key elements of CASL. In terms of the format today, Tim and I do have some practical information that we do want to relay to you by way of overview. We also expect that you're going to have some practical questions that can be asked. We hope that we can answer those questions in a practical way. And I say hope because at this point, we have no actual experience with CASL on the basis of which to respond. No one does. In that regard, we're rather like Christopher Columbus or Neil Armstrong. We've got all sorts of theoretical information on the basis of which to respond to a new reality, but no actual knowledge of how well we're going to be served by that theoretical knowledge when reality arrives. Reality arrives on July the 1st, and at this point, Tim Law arrives to start into the panels that you'll have in front of you.
Thank you, Doug. Good afternoon, everybody. I hope you can hear us well and that you do have access to a computer and not just a telephone, and that you can now see the slides. We'll go through the points. As our moderator has just said, please type any questions that you have into the chat box. That way we can see them and we can deal with them. We expect you to ask questions. We hope that you will ask questions, and we look forward to answering them. So what is CASL? And we're all calling it CASL, even though the actual name of the act is humorously long and hard, frankly, to follow. But it's important to remember that it's a federal law, and that means that it's going to apply all across Canada. It relates, as you'll see in the first point, to the sending and the content of what we call commercial electronic messages. We'll call them that today, we'll call them messages today, and we may call them CEMs today. Feel free to use any of that terminology. As Doug said, it comes into effect on July the 1st, a couple of months from now, and that relates to the sending of the CEMs. There is then a little leeway to the beginning of next year with respect to the installation of computer programs. We won't be speaking today about the installation of computer programs, but that is another part that the Act deals with. It's obviously important if that's something that you do, but we're assuming for today's presentation that that's not relevant to our audience. Lastly, it comes into effect 3 years from this Canada Day in relation to what are called private rights of action or private claims, and that is your ability as a person who has been harmed to start a lawsuit against someone that you say has done something that has somehow breached the Act and caused you harm. Let's go to the second slide. Well, that's not, yes, that is the second slide. The third slide is the second with text on it. So what is this CEM? Oh, someone was typing a question and they've stopped. Okay. What is a CEM? Broadly, we say broadly because that's probably something that's easy to help us as much as it is you, described as an electronic message that is of commercial character whether or not, so regardless of whether that specific message is sent with the expectation of profit. It includes messages that promote a product, a business, or an investment opportunity. Given the audience today, we'll be obviously focusing on products and services, the sort of things that you are out there selling to your clients, because I think that's probably most relevant. Next, it includes not just email, and that's something to be aware of. It's very much, as Doug said, an all-encompassing act, and, covers all sorts of electronic communication that you may not otherwise think would be included. You have there something that's being sent to an email account, instant messaging, and that would include the sort of messages that come now on most mobile devices with the BBM from BlackBerry. It would include your basic SMS message that's going from one device to another. It would include the iMessages that the Apple users have. It also includes telephone accounts. It also includes other similar methods of sending a message, and we'll talk a little bit about further down electronic message systems. Lastly, you'll see that it includes sound, voice, and image messages. And we have a question. Congratulations, Rick. You win the prize for being the first person brave enough to type in a question. Followed quickly by Barbara. Well done, Barbara. Will this apply to social media which might generate an email? For example, methods of Facebook groups. That's a great question. Thank you, Rick. That deals with electronic messaging systems. And thus far, the research that we have been doing into exactly that question leads us to the conclusion that, in fact, it applies to it, but because of one of the exemptions or the carve-outs of the legislation, because when you sign up for Facebook, you choose to use their system, you also choose to allow people to send you messages, chances are, no, you won't have any problem sending the Facebook messages. Barbara's question is there a specific number of recipients that constitutes spam, or would be included in these CEMs? No, there's no specific number. A single message could be that. Is a telephone call considered an electronic message? Yes, it is, but there are exemptions for that. When you say soft messages, Dina, I'm assuming you mean electronic messages, or you may mean soft in the sense that it's not a hard sell. So let's assume that what you mean is it's not a hard sell, but even a soft sell is going to be something that's commercial in character, regardless of the expectation of profit. So yes, it will. We've discussed with various people the idea that if you simply wish to send a message to any of your clients, or you track their birthdays, to say, "Happy birthday, John, regards, Dina," that is not going to be a commercial electronic message. But as soon as you start adding things to it, it will become a commercial electronic message if it's doing more than that. Next question from Brenna. I'll read it from here, sorry. Oh, cold calls, okay. Does that apply? It applies to telephone, but there is a carve-out for telephone. Will this presentation be emailed to us after the webinar? Yes, we're receiving an indication that it will be. And yes, there's a fine line, a very fine line, and we love fine lines, Dina. That's why we're here.
Even though there is a fine line, the advice, the counsel of caution, I guess, is to assume that pretty well any electronic message is likely to be caught by the all-embracing definition of a CEM. Tim's example of Happy Birthday, John is about as far as you can go without getting embraced by it. And frankly, aside from a happy birthday message, there's not an awful lot of electronic messages you're likely to be sending to clients or potential clients that aren't being sent with a commercial motivation. So your best bet, I think, is to assume that virtually everything sent electronically is likely to be caught unless it falls within one of the exemptions that we're going to be talking about shortly.
And I should have said that from the beginning. We are suggesting a very much a conservative approach, so that if you are to err on the side that there is the possibility it's a commercial electronic message, and assume that you need the consent to send it.
That's you, Corley.
Sorry, yes.
Facebook.
Coralie, Facebook, though, when you allow people to send you messages, have you not allowed them to send you commercial messages? And the answer to that is yes, you would be allowing them to send you messages. The question is, what kind of messages would you be allowing them to send you? And in the circumstances of what are called electronic message systems, like a Twitter, like a Facebook, you in effect have given consent, query what kind of consent, to receive messages from people. And let's move on because it may be better, go down here, to get into the issues of consent. Well, I tell you what, let's try and deal with the questions on the screen first. Does this apply to marketing that someone subscribes to? If you say, does this, yes, this act would certainly apply. The good news is that if you have obtained from them a subscription, meaning they have consented to have you send them information in relation to everything Europe, or everything adventure, or everything, South America, then they've given you their consent and you'd have it under the Act.
As a recipient of a lot of marketing subscription-based material, I can tell you that a lot of law firms and legal marketing organizations are hitting us with requests for express consent, and they're clearly doing so in advance of the July 1 transition. So they've got that express consent for reasons that we're going to get into in the next panel. So in answer to Andrea's question, the answer is yes, it does. Even if you subscribe, you either have already or will, between now and July 1st, no doubt be asked to give express consent so as to open the floodgates with respect to specified types of material thereafter based upon your express consent. And that does bring us to the next panel, which talks about how after July 1, there's a need for the recipient, whether it's you, the recipient, or whether it's your clients and potential clients as the recipients, to have consented to receive a CEM, as Tim has defined it. That consent can either be express or implied, and the onus is on the sender to be able to prove that either one or the other types of consent was obtained. So there's a whole database management issue that flows from CASL that we're all going to have to wrestle with, especially because a request sent out electronically after July 1 saying, would you please give me express consent to receive more of these things, is itself a CEM, which can't be sent out unless you've got consent. So you're in a catch-22 if you wait until the 2nd of July to make that request, and that's why, as I said, all these marketing organizations are hitting us with requests now in advance. And it's also clear that from the legislation that we're dealing with an ability of the recipient to opt out at any time, whether it's implied or express consent. It can be withdrawn at any time, and we'll talk about the methodology a little bit later on, but it's very definitely a pro-recipient regime that they're trying to establish. Yeah, we'll draw it in.
So let's talk about some of the exemptions. What does and doesn't fall within what's called a CEM? And some of these you might find quite obvious. They're messages between individuals with personal or family relationships, sent between employees of the same organization, sent by a representative of an organization, and we've said there that that's not yet been defined. So it will be, sorry, I took my eyes off the screen and went over to the questions. concerning matters of the organization where the recipient is a member of the organization. Messages sent in response to a request, inquiry, or complaint, or where the message was solicited by the recipient. Now, that is going to be a very important exemption, or an example of where the Act won't catch you. If someone sends you an inquiry, you are allowed to respond to their inquiry and provide them with the information that they've asked for. That trip, their lifetime trip for their 30th wedding anniversary around the world, you can carry on and send them information about that. Messages sent in response, sent in regard to a legal obligation, less likely to apply in your circumstances, but that is also exempted. And messages that complete or confirm a commercial transaction already entered to with the recipient. For example, confirming the booking and sending off all of the documents that are required. Messages that provide safety, warranty, or recall information about a good or service that the recipient has used or purchased. Messages that are interactive two-way voice communications. So if you are having a telephone conversation with someone, even though that would qualify as a commercial electronic message, it is exempted. Similarly, if you send a fax to someone, and if you leave a voicemail message for someone, those are also exempt. I'd say that isn't really surprising, because it isn't the quote-unquote old technology of telephones and faxes that we're trying to deal with here, but rather the brand new, albeit not brand new today, email technology that's extremely easy to deluge people with. Messages on behalf of charities or political parties, and lastly, messages sent and received where the necessary information to unsubscribe or opt out is included in the platform. And there you see the reference to the Twitters, the LinkedIn, the Facebooks. We didn't include the Pinterests and other types of Snapchat in there that perhaps the younger members of the crowd might use. But those are what's referred to as electronic systems. And in effect, when you go into them, if you sign up and you want to receive my Twitter feed, you've already given me your consent, because you've signed up and said, I'm going to follow law and listen to what he has to say. Similarly in the other channels.
Just before moving on to the implied consent, I'm seeing in the questions a bit of input about forestalling the questions and just moving through the presentation, but with the questions at the end. We'll try to get the right balance between the two, because we do, as I said in the introductory material, have some material that we do want to convey to you, but we also want to try to be practical in responding to your real questions. So it's a question of balance. Tim has talked about express consent. The implied consent exists if the recipient that ultimately receives the CEM has conspicuously published an email address or disclosed it to you, and has not said, here's my business card, but please don't send me any CEMs. So put another way, if you get a business card from somebody, or if you can find it on a web advertising or in a newspaper, in the absence of a don't do it, you probably have the implied consent. Better to have express, but that'll at least get you through the implied process. You also have implied consent if you have an existing business relationship, which we'll talk about in a second. There's also a non-business relationship, which is not going to be something that we're going to be getting into in this session, but the business relationship does allow you to do so, and that existing business relationship exists if either the left-hand side or the right-hand side tests are satisfied. On the left-hand side, if the recipient has made a purchase, has done a deal with you, or even barter, in the previous 2 years. So you're going to have to track that 2-year timeline, that's that data processing issue that I referred to earlier on. And on the right-hand side, if they made an inquiry, which hasn't materialized in a deal, you've got a 6-month window. Once again, you're going to have to track your timelines. In both cases, that implied consent expires before the 2 years on the one hand, or the 6 months on the other hand, if the recipient says, I withdraw. We'll talk about the methodology for withdrawing and unsubscribing later on. It's fairly easily done. The onus is basically on you, the sender, to be able to prove that you've got consent, express or implied, and you've got to have to track the 2 years and the 6 month windows, and you're going to have to respond quickly if in either case the person says, I unsubscribe. The express consent doesn't expire. Implied consent does. Express consent, once given, continues until and unless the recipient ends up saying, I'm out. I want to withdraw. The onus still remains with you to prove that you got express consent, and express consent to be valid has to contain the necessary information, which is who you are, where you can be located, what your web address is, what your telephone number is, and the nature of the material that the recipient is expressly consenting to receive. You may have express consent to receive anything about golf, but that does not give you express consent to send stuff about scuba diving or bird watching. So the onus is on you not only to prove you've got express consent, but what it applies to.
And let's just answer one of the questions there that I see coming from Leslie Moore, relevant to this. The short answer to your question, do I need to store emails to refute a future legal challenge? You need to store either the email and or something that details you in fact received consent expressly because someone gave it to you, and in that case that may be right in the email, and or the concept that you have implied consent, at least so that you know within the last 2 years or 6 months, depending on if it was a purchase or an inquiry, that you have consent. The other question I notice in blast emails, if you have an unsubscribe on it, would that be okay? Well, it would only be okay if you either sent it before July 1st, which is what a lot of people are doing and what we're advising people to do, so that you're allowed to send a CEM. But if you send it after July 1st, your blast email number, let's say of 10,000 people, is no longer an email database that you can necessarily use. Just having an unsubscribe mechanism in it, as well as your contact details, etc., won't win the day. There was one other that I saw that was relevant, and that is if I have the consent by telephone, do I then need to obtain it in written format? Do you have to do that? No, but that's the same as when people ask me, well, do I have a contract if it's not written down? Yes, you have a contract, but it might be difficult to prove it. So in this case, if you spoke to the person on the phone and you said, this is who I am, and you said, this is what I do, and you said, would you like to receive electronic messages about X, eggs and bacon, and they said yes, and you made a note, and you have that in your file, you will be able to say, I spoke with them on July 17th, 2014, they gave me permission, and that's why I was sending it. So you don't have to get written consent to back it up, but it may be easier in order to, in order to prove it.
This is from a practical point of view. Think your way through how you're going to do that. That is to say, Tim had talked about making a note in your file. Are you going to have all those files kept for several years in your office? Are you going to be able to find it within each file? Or are you going to want to establish a single database where you make record of the date and time of the telephone conversation or the face-to-face conversation where you got oral consent, rather than having to store it in a whole variety of different places? That's an entrepreneurial decision that you're going to have to make. That question came in from Thelma, and she had an earlier question which has now disappeared from our panel, but let me just answer that one. She had said, if a person says, I want messages or emails about specials over the course of the year, is that enough? And the answer is yes. If the person has given you express or implied consent, then you can continue to send them for those specials, but once again, If the consent only relates to specials, you can't go beyond that and start sending information about golf if it's not under the definition of a yearly special.
Let's deal with both of those questions about the international nature or the Canadian nature from Bob and Rick. The short answer is it applies to any message that is going from or coming to a computer system in Canada. So that means if, let's say, simply a computer system, the definition is used from the criminal code, but a computer system is your computer, it would be your iPad, it would be your slate, it would be your phone. If you are in Canada and you send it, then it will apply, and if people from outside of Canada have still got lots of people on their email list that are within Canada, it will also apply. So it does, in effect, apply to people in other countries, but it isn't what the Americans would call a long-arm statute, because we're still only dealing with things happening in Canada, the sending or receiving of an electronic message.
There is a minor exemption for that in that if it's, say, an American company that's sending what would fall within the definition of a CEM to an American consumer who happens to be vacationing in Banff, the fact that he receives it in Canada is not going to be a violation of CASL on those sort of one-off situations.
And what if you are using a server in the U.S.? That gets even more fascinating, Bob, but I don't think we'll get into the depths of that in this presentation. It starts to get very interesting. It fascinates me, but it might bore everybody else in the room. Barbara says you'd be wise to send an email blast for express written consent. Yes, you certainly would, and that's what we're encouraging all of our clients to do prior to July 1st to obtain the golden ring, which is express consent to send things that you have asked somebody for their permission.
And when you are asking for that express consent, you're going to want to make sure that you're doing it specifically for what you're going to send, but also you've got to be asking specifically to have permission to send a CEM. The rules say that you can't vary that permission in terms and conditions or a long, multifaceted, legalese-laden passage that is not clearly able to be seen by the recipient as applying to CASL legislation. It's got to be separately set out. It also has to be based on an opt-in protocol. That's one of the differences between the American and the Canadian. In the American regime, there's an assumption that everybody is willing to receive spam unless they say stop. The underlying assumption in Canada is that we don't want to receive spam, or CEM, sorry, unless we specifically say, yes, please send me a CEM. So we have to have an opt-in. You can't have the default check box to say, yes, I want it. You've got to have the unchecked box that forces the consumer, the recipient, to say, yes, I do want it. The third bullet on that screen says that the purpose has to be clearly identified. We've talked about that, the difference between golf and scuba or bird watching ventures has to be very clear. And so the more you can target the nature of the material that you're sending, the easier it will be for you to defend yourself if later on you're accused of having gone beyond the parameters of the consent that was given. You have to provide the name of the organization seeking the consent along with the contact details that are set forth there. And again, in each case you have to indicate that there's an opportunity for them to unsubscribe at any time. There is a transition. We're saying that July 1 is the implementation date, and it is, but there's a transition period where there's an assumption of implied consent for a 3-year window. So if it exists if if there's a business relationship, and then if the business relationship is formed after July 1, then it's the implied periods that we referred to earlier on the left side and the right side of the panel. And as the bottom bullet says, it's best to convert implied into express. The travel counselors that are involved in this webinar know that they're always being implored to convert an inquiry into a sale. Your employers, your managers, your owners has a longer duration than does implied consent.
Let's try and deal with a few more of the questions. Would this apply to a survey sent for a trip and they have taken without any future sales questions? Oh, already. What? That's fine, I can see it. Without any future sales questions. That's a great question, Anita, because the first test to be dealt with is, would that then be a CEM? Would it be a commercial message, and would there be, or regardless of whether there would be profit? I would suggest to you, once again, the conservative way to proceed is that you're only sending that survey because you have an interest in finding out about what the person says so that you can sell to them again, or you can use that information for some commercial purpose. So I suspect the answer to that is yes. It would depend how it was worded. Trudy, will you be providing us with a sample wording? There is sample wording if you go onto the CRTC websites, and if you check on the Travel Watch website, you'll see that they provide sample wording that you can use as well. A chat about over coffee, because I think what you're dealing with there is you're suggesting you're on their website when you book, and if you are on the Avis website when you book, you may not be dealing with commercial electronic messages. You are going through a website. You would be actively telling them you want to do something. You likely wouldn't get into a Canada versus USA legislation issue. Rick, one method of expanding subscription is to ask friends to forward email to forward the email to colleagues. How is this affected? It might be the referral question, but if your clients were to send an email that you send, let's say, with the trip of the week in it, and they send it to their friend, and their friend comes to you, that would be a wonderful way of dealing with these things if they do in fact come back to you. And there is also what Doug was referring to as the referral, the one chance referral. And that's another, in effect, exemption that that we'll deal with, but if you can get that, you'll be in a good position as well.
Pauline's question talks about rebranding. If it's the same company that had got operating, which is more than a rebranding question, then it's a different company, and the consent would not apply unless there was an overt transfer, an assignment of that list, mailing list, approval list, and that's something that we're going to get into at the very last session where we get into the practical suggestions. So I think we've done transition, and we're now getting into the content that has to be included in the CEMs.
So, back to the top to the two concepts. The first concept is you have to have someone's consent to deluge them with emails. Secondly, when you send those emails, they have to contain certain things. What do they contain? Indicate the name of the organization sending the message along with contact information, and that information has to be valid, meaning that it's still going to exist for at least 60 days afterwards. It's also possible, and it's contemplated in the legislation, that you'll be sending on behalf of another entity. Those entities need to be identified, and you need to have contact information for at least one of those entities. It must state that the recipient can unsubscribe at any time, and it must include a working unsubscribe mechanism. Nothing in there can be misleading or false in terms of subject lines. And here we are with what we're referring to as the referral exemption, so that you can get a referral from someone and you are allowed then to send that first email to them, and it literally is only the first email. You can do that even though it would qualify as a CEM because of this referral process. Okay.
Just transitioning over to the question, that referral process that Tim refers to is designed to allow for a recommendation of an accountant, a doctor, a lawyer, a travel agent, whatever, so that you can refer somebody on to somebody else, and then the travel agent in this example can follow up with one CEM to the person who is being referred, but after that one, you're going to need to have the consent of the recipient in order to send out a further CEM. Steve has asked a question on the right-hand side about policing of consent. There are, in fact, 3 different organizations that are looking after enforcement of CASL. There's the CRTC, which is the Canadian Radio, Television and Telecommunications Commission, that regulates cell phones and televisions and so forth. There is the Office of the Privacy Commissioner, and there is, I'm blanking, I'm feeling like Governor Rick Perry there in Texas. I'm blanking on the third. CRTC, the Privacy Commissioner, and
back to you shortly with that one.
Yeah.
There are 3 though. That is certainly the case.
Senior moment, sorry. So we'll follow up with that one, Steve, when the penny drops. So I think we're on to the next panel because we've caught up with the questions.
There's one more there. We get all of our clients to sign a booking form explaining charges if we have a standard clause saying something like, I agree to receive weekly specials or itinerary change updates and attach it to the client's file. Would this be sufficient? It would have to be a standalone. It can be in the same piece of paper, but it's got to be very clear. The point is it can't be hidden. You can't say, well, you signed up for this, if it's not clear what the person was signing up for. That's the fundamental principle in terms of getting someone's consent.
I can get back to Steve. It's the Competition Bureau is the third regulator. So you've got the communications people at the CRTC, the anti-competitive people at the Competition Bureau, and you've got the Office of the Privacy Commissioner. Those 3 bodies signed earlier this year a memorandum of understanding that sets forth who's going to do what amongst them, so they're not either tripping all over themselves or leaving a gap between them. That MOU also speaks to the extent to which they are committed to cooperate internationally with their counterparts in other jurisdictions, like the FCC in the States is the counterpart for the CRTC. The idea is that because electronic communications are so international in nature, we can't have just a regime here in Canada that's isolated and insulated. There has to be cooperation so that if the Canadian authorities see a problem with an overseas sender of a CEM, they can contact the Italian or the Argentinian or the Australian authorities. And conversely, if those authorities in those other countries see a problem that involves a Canadian angle, the 3 regulatory bodies that I've identified are committed to cooperate with them as well.
Let's deal with travel masters and your confusion. You said that express consent cannot be requested after July 1st. During the transition period, there's implied consent for 3 years. There is implied consent for 3 years if you meet the test that Doug spoke of, and if you have someone's implied consent to send them emails, you can in one of those emails ask that they expressly consent, and that way you'll have the express consent. The people we would be requesting express consent from would be our existing clients. Well, and if they're your existing clients and you have implied consent because it qualifies under the business relationship, you're okay. But just because you have an existing client, if that person does not qualify as having a business relationship as of July 1st, you will have an issue unless they come back to you and ask you a question, or they fit within the other exemption that we talked about, and that is that there is an email address out there. Let's say, for example, you deal with IBM, and IBM has a specific person who deals with the purchase of all travel for the Toronto office. That person's email address is on the website. You know that that person organizes all the travel for all of the people in the Toronto office. That exemption would apply. That would give you the implied consent, and you could ask them at that point, post July 1st, to get the express consent. If a customer withdraws consent, how much time that the business... Sorry, that's not coming through very clearly. If a customer withdraws consent, how much time does the business have before stop sending the messages?
And that'll allow us to move to the next panel, thank you for the question, which deals with the unsubscribe mechanism. You'll see at the bottom, you have to process it within 10 business days. You can't say, oh, once a month I'll tidy up my list. You've got a 10 business day window within which to respond. The second bullet talks about it having to be a one-step process. Oftentimes in the past, when you received something as a consumer, they would have at the bottom an unsubscribe protocol, and if you check on the unsubscribe, you'd get a further window that said, are you sure? We're giving you a second chance. That's not acceptable under the post-July 1 regime. It's got to be a one-step process where the consumer could say, I'm out of here, I'm gone, that's it, and then you've got 10 days within which to process it. Moving back up to the top panel, your unsubscribe mechanism has to contain that information that's set forth there, and your coordinates have to be valid for at least 60 days. That means you've got a little bit of planning to do if you're in the process of switching websites, telephone numbers, as part of the purchase and sale of a business. If there's going to be a change in any of that data in the next following 2 months, you've got to take it into account, or you're going to be running afoul of Castle.
Dealing then with Trudy's question, the simple answer, Trudy, when you receive this list or information about people who've consented to receive information, quote, from the exhibitors, it's going to depend purely on what the wording was. And was it clear that they were giving consent to receive information about X? And was it buried where they wouldn't have clearly understood that they were giving their consent to receive that information?
We're turning the corner and heading into the final 10 minutes of the webinar. Based on the theoretical knowledge that we talked about at the start that we're all now flush with leading into July 1, we now move into the practical. What should you do with your staff? It's a question of making sure that all of your staff are informed. It's an easy thing to fall into to say that I'm the owner, I'm the manager, I've got it under control, but you've got no control over what your staff are doing in the way of sending out electronic messages, emails or Facebook or otherwise. So it's our suggestion that they all have to be aware, at least at a fundamental level, that they may be bringing your company into a position of risk if they send out a CEM without understanding what needs to be done. So as part of that, you're going to want to be reviewing your communication strategy to determine who sends messages, what do they contain, are they CEMs, and our suggestion is pretty well everything is going to be a CEM, and therefore the key question is going to be, do they fall under any of the exemptions so that I can breathe easy when I send them out? If I can't find it falling under an exemption, then what sort of consent am I going to be relying upon to justify sending out this CEM? You're going to want to have express consent in an ideal world, implied that can lead to express consent if you can convert the implied into express, and you're going to want to be able to document it so as to be able to prove what was obtained in the way of consent. But the nature of it is, because if it's implied, then there's an expiry date, and you're also in either case going to want to be able to prove what the recipient agreed to receive, so that you don't wander too far afield from what the person did want to receive and start sending them stuff that they haven't consented to. The inventorying of email addresses and messages, as I said, is a major back office aspect of this castle legislation. I'm sure that after 10 years, the government authors of the regime are aware of the documentary consequences of it, but what at first blush just seems to be a front office issue has an even bigger back office component to it in terms of being able to document all of this stuff, I think, which is the categorization as well as the type of consent, and then diarizing the consent. And when you diarize, you're not going to want to diarize for the 2-year anniversary and the 6-month anniversary, I suggest. You're not going to want to diarize only those. You're going to want to diarize a week or a month in advance of the expiry, so that you can try to revive/extend that consent before it expires. Top of the next one, all the required information. Tim had gone through that in terms of what information has to be provided. We've talked about the unsubscribe mechanism and how quickly you've got to process it. 10 days. The key message, I think, coming out of today is that you're going to want to try to make contact, if possible, before July 1, so as to get that consent locked in. You're also going to want to take a look at your file opening protocols, so that when you have a new relationship, you're capturing that consent expressly as part of it, so that you don't have to worry about it as a separate process. It's part of the file opening process. And the one on the final on the page is the whole idea about logos and catchphrases that are sometimes part of company logos. That Happy Birthday John email that Tim referred to half an hour ago may be converted into a CEM just because your logo talks about the business that you do. Come to us for all your travel needs as part of your logo converts a happy birthday message into a CEM. And so you're going to want to monitor that for care. As Tim scans the question box to take over after we've done the practical implications, there are big penalties. Tim had talked about earlier on about the July 1, 2017 right of private action. That's where one citizen sues another, but there are also governmental penalties and administrative penalties, that's what the AMPs are, that are very significant. One assumes that government regulators and enforcers aren't going to be going after the one-off travel agency in a small town, Saskatchewan, but they're going to be going after big companies. But whoever they go after, there are significant penalties, which is the first bullet. There is also, as of 3 and a bit years from now, a right of private action, and when you take that right of private action and combine it with class actions, there's another huge prospect of liability that looms. From a practical point of view, think of the implications when you come to sell your agency. I know that in my practice, when I'm acting for the purchaser of a travel agency, I'm going to be wanting to get a representation and a warranty from the vendor with respect to castle compliance. And I'm going to want to see how castle compliance has been effected, because there is a potential risk for the purchaser of having to pay the price for a violation of castle that was effected by the vendor during the vendor's ownership period. And if I'm not satisfied as a purchaser's lawyer that castle has been complied with by the vendor, I'm going to be recommending a reduction in the purchase price or a holdback from the purchase price so as to insulate my client, the purchaser, from the consequences of the vendor's violation of castle. We've talked about the international implications of this legislation. I think also I'd mentioned earlier on the fact that the Canadian assumption is that nobody wants to receive a CEM unless they expressly say so, whereas the American assumption is the exact opposite. And so we caution you that when you're reading anything about spam rules, if you're reading from an American publication or reading of an American author, they may be starting from an assumption that doesn't apply in Canada. So you're going to want to take a grain of salt to whatever you read there.
Okay, let's see if we can get through a few questions in the last 4 minutes. If you have expressed consent for CEMs from one individual in an organization, does that allow you to send CEMs to others within that organization? And the wonderful legal answer to that question is, it depends. Aggravating as I know that answer is, it will depend. If you're dealing with a huge organization and you have a relationship with that travel purchaser that I referred to earlier, that doesn't necessarily mean that you are going to be able to then send all sorts of emails to 30 or 40 other people that have nothing to do with that particular physical office or the same sort of processes. Some clients want not only info on all-inclusive packages, but air only, adventure only. Does your consent have to list every possible type of travel? Well, that's an interesting legal and pragmatic question. Lots of commentators have said, well, because you only get consent for the purpose to which you described, you should draft very broadly when you say, do you want to receive information from my travel company in relation to all travel products? And that's certainly one way of doing it, in the hopes that anything you send will be considered a travel product or perhaps a service. The difficulty with that is that you could be deemed to be sending something that the person didn't legally agree to, and I would suggest, equally importantly, you could simply be aggravating the person. For years, they've only received information from you about unusual, exotic and or adventure travel, and you think that that gives you the right to start sending them all sorts of information about trips to the Caribbean at March break. First of all, there's a question, do you really have consent to do that? And secondly, are you not just aggravating the person and in effect spamming them just because you said travel products? You're going to have to use your judgment in that and try and know the crowd that you're sending to. To fall afoul of CASL rules and regulations, a client or CEM recipient needs to have filed a complaint. Well, no, you can fall afoul of it as soon as you send the CEM. Are you going to get into trouble? That's the next question. I hit the person, am I in trouble? Well, you've breached the law, but whether you get in trouble or not depends on any enforcement. So, yes, there'll be enforcement issues, possibly.
But from a practical point of view, you're probably right, Steve, that in the absence of a complaint, the regulators are not likely to pick up the issue.
I send a lot of attachments with my email for trip quotes. As long as it is a reference to the request, I will be okay, even though some of the sites have additional tours that they can access. Back to a similar answer to a couple ago, and that is yes, it will be okay, but the assumption is behind that yes that you've got express consent, or ideally express consent, but possibly also implied consent for that sort of thing. Similar, in other words. I use my work email to communicate with my kids' schools and other personal venues for the basis that they will find out that I am a travel agent. My signature states my job title in connection to our website. Would this be considered a CEM? You've already answered your own question, Beth. Well done. Yes, because the reason you're doing that is to get them to come to you. And, okay, we'll answer this last question. What about press releases to media organizations or reporters? It depends how you send them. If you're sending them by carrier pigeon, you'll be okay. If you're sending them by email or other electronic message, you may well have an issue. Save and accept, I bet you, media outlets will be the single easiest place to get express consent from, because they really want to hear everything you have to say. All right, we've been told we're allowed to answer the last question, and it will be the last question, so that we're keeping in line with what we were asked to do. I picked up a real estate, good try Steve, I'm afraid this is the last one. I picked up a real estate magazine where all of the agents had their email addresses. I added these to my database. Is this implied consent as they publish their addresses? Yes, possibly, as long as the thing you are trying to sell them, for example, a flight, would fit within, their job description. Now, the example that we've given to a few people is if on the website in my travel management company example, you know that Dave is in charge of organizing travel for IBM Toronto, his email address is there, you know that his job is to organize travel, you can send all you like to that person because it relates to their job, finding travel. If you could see the HR department or the accounting department's email addresses on the website and you tried to start sending them information about travel, I'd suggest to you you'd run afoul of that because you know that their job is not to buy travel and you are then spamming them with nothing really to cover you. Thank you all very much.